Welcome, everybody. As you may know, the work of the TAXE 2, this committee that looked into the tax rulings and other measures in nature or effect, has come to an end. The final report with all the recommendations will be voted around noon. And before that, we would like to give the chair and the rapporteurs the opportunity to present the recommendations. Mr. LAMASSOURE, may I ask you to take the floor first?
Thank you in French, if you allow.
Thank you very much and good morning. Well, yes, today marks the end of the day, end of the period of work of the Tax 2 committee. We're going to have the vote at midday today, so we're giving the press conference without knowing what the results of the vote will be. But we are very much hoping, of course, that we will attain a majority, a broad majority, as was the case in the Tax 2 committee. Thanks to the work of the two rapporteurs, that we have been able to make even further progress and highlight the value added that the European Parliament can bring to bear in the fight against aggressive tax planning on the part of multinational companies. This is work that we had already started with the Tax 1 committee, where we were looking at the information gathering inquiry stage, and then of course there was the stage of submitting proposals, and of course now we're taking a further step in trying to clarify what it is we want. And the Tax 2 committee has held 11 meetings, 3 joint meetings with the Econ, Jury and Development committees. We had 2 missions abroad, one to Cyprus, one to the United States. And the Tax 2 committee has also organized hearings with further representatives of banks and also government representatives of those countries that are deemed to be non-cooperative monarchy, Guernsey, Jersey, Liechtenstein, and we also received a representative of the government of the Cayman Islands and also heard from a representative of the Alain. And I must say I'm very satisfied because this is an area where the European Parliament has hardly any competences, corporate tax, but through the Tax 1 and Tax 2 committees, the European Parliament has managed to confer its stamp of credibility on this work. All these companies, all these banks, and, well, the big fours, basically, all of these high-ranking individuals and personalities that we wished to invite to a hearing, we have managed to receive them. And I think this does serve as a precedent for further committees that have been, committees that have been set up, committees that will be set up in the future. There's the EMIS committee, following the EMIS committee, following the Volkswagen scandals. They have not managed to persuade Commissioner Verheugen to come before their committee. But in the way we've worked, then we have managed to establish the credibility of the European Parliament as a partner for the national parliaments as well in this kind of work. We've had joint meetings, 4 joint meetings over a period of 2 years. And also, as I said, together with the United States, there was the Chamber of Representatives, the Senate, the representatives of the Republican Party and Democrats as well. And obviously we know that they are the OECD proposals, so this means that we are working together with our US partners, the joint hearings. Obviously that can only really happen once the elections that have taken place in the United States. But I think this is a very worthy legacy that we are leaving to our successors and to the lead committee that is going to be responsible for monitoring and guaranteeing follow-up on these issues. The main area of work that lies ahead of us now, and it'll be up to the Econ committee to do this, is the definition of the role of the beneficiary and everything to do with CCCTB. Thanks to LuxLeaks, the Panama Papers, and the pressure that the European Parliament has managed to maintain through our committee vis-à-vis national parliaments and the member states. Over a period of 11 months, we have been able to make a lot more progress on this file than it was possible over the past 10 years. Obviously, there is still a lot to do. It will take time. But I think we have managed to turn this very important page, and this represents very good news for the taxpayer and the European Union.
Mr. KOFOD, may I ask you to take the floor?
Yeah, thank you so much, and also, first of all, thank my good colleagues, President Alain LAMASSOURE and also Michael THEURER, my co-rapporteur, for the great work they have done in the committee, and for the outcome, the report we are going to vote on today, a very comprehensive report. I think a report with many achievements from this Parliament side on, demanding an end to aggressive tax planning and tax avoidance. And if I, in a nutshell, should present what's in the report, if this report has been in place 5 years ago, Mossack Fonseca would have been a low-rent local law firm in Panama and nothing more, just to give one example. Tax avoidance is a terribly bad judgment, but it's terribly good business for many, many people. That's a fundamental scandal of both LuxLeaks and the Panama Papers, and that's what we are trying to fix in this report. With this report, we are effectively destroying the business case for tax avoidance and aggressive tax planning. We are calling for tough new sanctions on banks, tax advisors, and companies who use or construct illegal tax structures. We are calling for repeat offenders to be driven out of the business, for holding tax advisors, banks, accountant firms directly financially responsible for the financial crimes they facilitate. And finally, we are calling for legislative action at EU level and member state level for better protect whistleblowers like Mr. Deltour and Mr. Alain. And this is something which is very important in this report. And also we are calling for reform of the Code of Conduct group so it will be more transparent and more efficient in its work dealing with aggressive tax planning schemes that we see in European member states. We are also asking for a rapid list of non-cooperative jurisdictions, tax havens, and clear sanctions against tax havens that are not cooperating with European Union to end this kind of aggressive tax planning and tax avoidance. So I don't want to go through the whole report. I'll say this is a very good report after a long and dedicated work by TAXE 2. And I have to thank also many of my colleagues, not only one sitting here, but also in the committee for many, many good inputs to the report. And I also hope for a broad support in the Parliament today. I think really this cause deserves strong support and a strong signal from the European Parliament. We are not finished with our work, but with this report we have clear recommendations to the Commission, to Member States, and we expect that they deliver on each of these recommendations that we have. Thank you.
Thank you, Mr. KOFOD. Mr. THEURER has been rapporteur also for the first tax committee, so for you it's the end of a long process. Mr. THEURER, the floor is yours.
Yeah, thank you very much. First of all, I would like also to thank our chairperson, Alain LAMASSOURE, who was the chairperson in TAXE 1 and TAXE 2, and we formed together a powerful team for the European Parliament. I would like to thank my co-rapporteur, Jeppe KOFOD, and the shadow rapporteurs, and also the Secretariat, the staff, and the Commission for the support. You know that as a co-rapporteur in TAXE 1, I was very much interested in having continuity. I was calling for prolongation of the work of TAXE 1 because we realized that we could not do all the aspects in TAXE 1, especially. We did not have the access to confidential, secret documents of the Commission and of the Member States. So against great resistances, we successfully fought to get the access to these confidential documents. Some of them still were denied the access, and I think we have to make it clear here that that is not acceptable, that the Member States in this case, denied the access to elected members of the European Parliament. The first time in the history of the European Parliament, as far as I'm informed, these documents were brought to a secret reading room in our premises, and we have proven that we can deal with that in a very responsible way to make that clear that the European Parliament takes this responsibility, and I think that is something which can be taken to future inquiry committees and special committees to strengthen the democratic control. Some of the findings from my point of view, quite a few things were already mentioned by Alain and by Jeppe. I would like to focus only on some aspects. First of all, of course, we are not able to go into the detail of the confidential documents, but if I say that there are public and other evidence or enough significant evidence that it is clear that the member states knew about harmful tax practices for years and discussed behind closed doors in Finance Minister Council and in expert groups, then that is the truth. So the member states were not able to solve the problem, the conflicts around harmful tax practices, and they were not hindered by Parliament or by Commission to find a solution, but in fact they could not, because they could not overcome the conflicts in interests, in different interests of member states. And that leads to the second conclusion. Yes, indeed, tax regimes, the architecture of tax regimes were and still are considered by some member states and by jurisdictions all around the world as a factor to attract businesses. So the question is how to design tax laws in a way that there is not a distortion or a mismatch of a fair competition. And from that point, we have proposed a number of conclusions. So our strongest argument is that in a common market with the freedom of capital movement, it is absolutely necessary to have some safeguards to secure a fair tax competition. That is CCCTB, that is automatic information exchange. That was done in TAXE 1 as well. There were already now laws in place by the Commission and the Council. We focused in TAXE 2 on the external dimension, and we already discussed about tax havens and whether it makes sense to visit them. And we did that before the revelations of the Panama Papers came to the public. So we have seen the problem of the transfer of money to tax havens. We tackled that, and we made proposals to have a common tax treaty regime. We propose a withholding tax so that it is guaranteed that each profit which is leaving the European Union has to be taxed at least once. So to conclude, other things were already mentioned, like a register for beneficial ownership, like reporting requirements, and what we call for is that the transfer pricing issue is addressed by Commission and Member States and the patent boxes. So to conclude, I think that TAXE 2 did what it could do in 6 months, a very limited time. What I would recommend to the Parliament is to follow up the issues in the Panama Inquiry Committee, but also I think it would make sense to consider in this House to establish in the future an own taxe committee or taxe subcommittee to follow up the issues, because these things are very important. And a last personal remark, what I still believe is unsatisfying is the fact that those who had the courage to reveal the LuxLeaks scandal were prosecuted and sentenced to jail, while those who had the benefit of tax privileges estimated amounting to some billion of euros, and those who took the political responsibility did not have to bear till now any personal consequences. That is effect which we have addressed, calling for a better protection of whistleblowers, but which could not be solved in the mandate of the TAXE 2 committee.
Thank you very much, Mr. THEURER. Are there any questions? Yes, please, in front row.
Catherine Fior, EU reporter. Mr. KOFOD, you have called for an EU register for beneficial owners, hopefully leading to a global register. Would this be done under the auspices of the OECD or a UN-type mandate? We see that 2 weeks before the Panama Papers revelations came out, the OECD gave Panama a clean bill of health. Can they be trusted? I have a number of other questions, but it's one.
Yeah, I think what the Panama Papers revealed that we really need to identify the beneficial owners behind shell companies and all type of entities in tax havens, in non-cooperative jurisdictions. So we are calling for a register in the European Union, in member states, for beneficial ownership, but we're also calling for it globally, because it's true that to be efficient, we need a global register. Also, I would say that it's important, which we're also calling for a study, to look whether we can make a register on ownership on financial assets, all financial assets in the world, an idea that has been also presented by economists, because that will be an efficient way to understand how people are hiding money and hiding away assets not to pay tax. So in this report we have this, and yesterday I have to say I have to commend the Commission for what they decided to present of a proposal also on beneficial ownership and registers in EU member states. That idea, and it has to also public registers, is a really good idea, and we have to support it, and we have to see member states following suit. You're right. In the OECD, it's a driving force of the thinking behind fighting base erosion, profit shifting, and tax avoidance. We need to do it also on the UN level. Fight for these standards to be implemented globally, endorsed by G20 and also by G7. I think this is important. I think the important for me is EU is taking the lead in this fight. We are doing it now with many of their proposals in the report here on our own single market in Europe. But we also, as Michael also said, has an external dimension here, which is very strong in the report. And there, I think beneficial ownership, identifying of that, fighting the whole industry behind tax avoidance, tax evasion, is very important, and that they will have severe consequences if they engage in this type of activities.
Si je peux compléter.
Well, if I could add to what Jeppe has just said, which was an excellent summing up, I can give you 2 examples of some of the important proposals that have been made and that we have introduced into the TAXE 1 conclusions and into the draft TAXE 2 report, which have been taken on board by the European Commission. There's country-by-country reporting, which will be made public. After a somewhat weaker proposal that the European Commission came up with, which wasn't quite so courageous, they amended that, so we now have that. And then we have this definition of beneficial owners in all these legal sort of structures, trustees, etc., spread across different countries. This is one of the strong points of our report. And as Jeppe has just said, then of course there is a text that includes a proposal to fight money laundering, and the European Commission has already, if you will, included some of our own ideas into their proposal, the text that we're going to be voting on now. And so I think that the work we've done, the European Parliament, is going to help speed up the reform.
Questions? Okay, so...
Yes, please.
Oui, bonjour. Est-ce que vous pouvez nous...
Yes, good morning. Can you tell us a little bit about the conditions, what kind of
complicated conditions was the storage of these confidential documents put into place. Weren't you a bit surprised? Didn't you think it was a tiny bit exaggerated, the way in which these documents had been stored? Well, the rapporteurs can, of course, give their opinion. Well, did you really... well, we had an institutional problem here. And I think we did actually make some progress here. And I think transparency, the cause defending transparency, was promoted in this case. On the one hand, you have documents that are in the hands of the member states and belong to the member states, in which the member states can work on and exchange amongst themselves within the framework of meetings, meetings which are occasionally official council meetings, and sometimes they are considered by member states as coordination meetings of national member states without it being an official council meeting. Then you have the Commission's documents and you have the Parliament's papers. What is quite clear here is that the European Parliament, and our colleague Toya already said this, the European Parliament has the right to be informed of all the documents, internal documents of the Commission. And that is what we received by way of documentation. The question that arises here really is whether we can ask the European Commission to supply us with the working documents which have been prepared by the member states within the framework of meetings such as the Code of Conduct Group. The Code of Conduct Group meetings are basically meetings of the Council of Ministers. But there is a rule, the relationship between the European Commission and Council, and this rule establishes that the Commission cannot circulate the Council's documents only if there is agreement by the individual member states. So we did talk to the Secretary General of the Council. We also talked to the presidencies, so the Luxembourg, the Dutch, and now the Slovak presidency, to see whether we could get these documents from the Secretariat, the General Secretariat of Council. And then at the end of the day, we actually managed to convince member states that, at least as far as the minutes of the Code of Conduct Group meetings are concerned, all of these minutes should be put at our disposal. Well, it was a bit like when we had to deal with the multinationals. Multinationals didn't want to come to our committee meeting, but then when we managed to get some of them to come, all the others were more or less obliged to come too, because if not, they would have publicly shown that they had things to hide. As far as the government's concerned, that is the minutes of the Code of Conduct committee meetings, well, about half of the government said yes to the handing over of documentation. And it's true that it was a bit of a complicated situation. It was kind of complicated in the sense that there were documents which expressed standpoints of governments which had not accepted the spreading of this information. But we did actually make public the list of those governments that did not want to cooperate. And basically, at the end of the day, all governments decided to accept the circulation of those documents. This, however, does not mean that we had access to all the documentation of the member states, but the minutes of the meetings of the Code of Conduct Group held over the last few months, they were sent to us systematically. I think it was a question of principle in the beginning, and it took up a lot of time, and we had to put in place a whole series of mechanisms which were quite provisional and specific. But as Mikael already said, in this way, in providing the necessary guarantees, we did have access to the most essential documents that we needed. And this made it possible for us to draw the necessary political lessons, which Mikael already referred to. It is quite clear that all the administrations, financial administration of all member states knew exactly what was going on in the other member states, and that political choices were made in all countries up till the moment of LuxLeaks and after the reactions of the European Parliament and the European Commission. And everyone agreed that they weren't going to get involved in their neighbours' problems. And there were, of course, reproaches that they could have made.
Some aspects on that. Thank you very much, our chairperson, because he was transporting the request as a whole committee to the Commission, and that was very important to get the access. So you asked what were the circumstances, and I can compare TAXE 1 to TAXE 2. In TAXE 1, we have seen some of the documents very, very late. We had to go to the Commission, to the GD Taxud. We were not allowed to take any notes or to take the notes we have taken with us. That was the problem. You cannot work in a complex topic without having any handwriting notes on what you have seen. So that was improved in TAXE 2, yes. Indeed, we could take handwriting notes and we could take them with us. We have seen more documents, we had more time for that.
In our premises.
And it was in our premises. So that was a huge step forward. And in fact, we have the same experience with confidential documents of the ECB. We deal with them in the ECON, no problems so far. And from that point of view, I think the distrust of the Commission and the Member States towards the European Parliament was not justified. But that is leading to the second question, which is an institutional question, a lack of democratic control, because national parliaments are not able to control, for instance, council working groups or the Code of Conduct group. They are not able to look into it. And European Parliament is not able to look into it either. So from that point of view, on the Council level, there is an evident lack of democratic control. We could close it a little bit. And even with the documents Alain LAMASSOURE mentioned, which were blackened, we had conclusions out of it, because first of all, if something is blackened, you also can read something out of it, because some were not blackened and other were blackened, and if you compare it, then you get conclusions. And many things we knew before, but looking into the documents, we got the proof, or we had the feeling that we were not on the right track. So from that point of view, I would conclude it was difficult, but it improved, and it should be even improved more in the future. So if I could give a recommendation, I would like to recommend that the role of the European Parliament in inquiry and special committees should be strengthened in future.
Yeah, very briefly, just to add, if you look at our report, we have some clear recommendations also when it comes to the Code of Conduct group and the member states, because you understand what goes on there is working in secret and with a unanimity principle. So the fact is that even if they identified harmful tax practices, it's very hard to get rid of them because they have to agree, all of the member states. And for us, looking into the documents, confidential documents, is also a problem because we cannot talk about what we see. I mean, we're not allowed to do that in a sense. We can use it for our own knowledge. It's very useful for the committee, but we cannot have any public debate about it because we cannot disclose what we have read in confidential documents. So what we are calling for is also much more transparency when it comes to harmful tax regimes in the European Union. We concretely in the report suggest that we can, in the European semester, require member states also to look into harmful tax regimes and deal with them, and have also in that process of the European semester with recommendations to the member states, a process where we can get rid of harmful tax regimes. So we have concrete proposals for transparency. We suggest institutional reform also to get rid of unanimity principle in the Code of Conduct group, so a member state cannot block harmful tax practices. And also we want to see this integrated in a European semester so we can have a more institutionalized way of dealing with it. So we have concrete proposals here.
One short last question.
Two short last questions. On the whistleblowing issue, Commissioner Moscovici was here yesterday and he suggested that it might be difficult to have protection at a European level and that this might be a national measure that could be introduced at a national level, if I understood him correctly. I wonder if you think that there should be a European level of protection for whistleblowers. And also, George Osborne has recently announced that he will be lowering the corporate tax level in the UK as part of its Brexit recovery plan. Do you think this will help or hinder a European common consolidated corporate tax base? I'm not sure I've got those words in the right order. Thank you.
Well, briefly. Well, I think we call for both guidelines on the European level to protect whistleblowers much better. I mean, what happened, personally, I think what happened in the Luxembourg trial is a disgrace, that you see whistleblowers that revealed illegal activities being punished and not rewarded, and the ones who are behind the illegal activities, they are still out there without any severe punishment. So I think that's really a problem. But so we call for European guidelines, and we also call for member states to revise their own legislation to protect whistleblowers much better, both. Then on the UK and the suggestion to further cut corporate tax rate till 15%, I believe was the proposal. Already they were aiming at 17% and now even lower. I think there's a risk, yes, that we see a race to the bottom on tax rates and corporate taxation. We have seen that, if you look historically, the trend has been very clear, and partly because of the huge amount of tax avoidance, aggressive tax planning. So we need to work closely with the UK on fighting aggressive tax planning, and also I have to say that I think we need to have an efficient cooperation, and the common consolidated corporate tax base is one of the good proposals in the EU to deal with some of the practices that lead to tax evasion and aggressive tax plannings. But I'm very concerned about the race to the bottom, that we'll see some countries trying to do that.
A very brief addition. If you look to the negotiations and the amendments, you can see that the whistleblower protection is very much disputed. Under the EU treaty, it's responsibility of the member states, but both co-rapporteurs are convinced that we need a European framework legislation, because in the trials we realized that the public interest in the national member state might be taken into account, but there is also an overwhelming public interest in a European Union with a common market with a freedom of capital movement. So from that point of view, a clear plaidoyer in favor of a European protection of whistleblowers. So let's wait and see how far we come today in the votes. One word on the tax rates. The major conclusion of this report and of the BEPS project is, and we recommend that the BEPS recommendations of OECD are implemented in the European Union in a binding way as an EU framework legislation, is to stop the manipulation of the tax base. So we do not want to stop the competition via the tax rate if it's done on the same base. So that is the major conclusion. Your question was, does it make the CCCTB more difficult if Osborne announces to lower the rate? No, but it still make it urgent to have the same tax base. And there we face a huge, a fierce resistance in the member states. Several member states declared that they do not want to have a common corporate tax base, and what they definitely don't want to have is a consolidated common corporate tax base. But the Parliament is, with a majority, I suppose, decided that we think that it is absolutely necessary in a common market to have this CCTB as soon as possible.
Thank you very much. As said before, the work in the field of taxation will continue in the inquiry committee on the Panama Papers. Most of the legislation is not co-decision. It requires unanimity in the Council, but some of it is. For example, the country-by-country reporting has been proposed in the update of the Accounting Standards Directive that will be dealt with by the Legal Affairs and Economic Affairs Committee. That was a proposal by previous Commissioner Lord Hill. Another proposal that's on the table is anti-money laundering directive. It will be updated shortly. It will deal with the final beneficiaries. This will go through LIBE and Econ. Other proposals that come from the Commission might require an opinion of the European Parliament. So the work and the thinking will not stop on this issue. Hope to see you in the future. Thank you for your attention.